Once again, Trump has lost bigly in court. Got to talk about this one. This is really good. There's a lot of other points I want to get to before I get into this, but this is great. Trump losing in court like no one's ever seen before. No one has ever seen a court excoriate a plaintiff like this. I mean, numbers like you've never seen before. I mean, this is, but it is really cool though. So welcome to the No Say Project channel. I'm Mark Stevens, and I got to talk about this. This is just great. It's the United States Court of Appeals for the 11th Circuit. Donald Bigly loser Trump versus the United States. Now, this has to do with the search warrant on his home in Florida. I mean, so he threw a fit, and remember, this is a former president. It was initially picked up by a Trump appointee. This is her, Eileen Cannon. All the experts are saying there was no standing. He had no standing to do this. The court had no jurisdiction. They did it anyway, and now the 11th Circuit Court of Appeals has made it official. I just want to point out here a number of different things. We're not talking about a nobody like me or one of you, or watching the channel here. We're talking about a former president and somebody who is of the elite. Now, he may not have as much money as he claims, but he's not poor. He is a former president of the United States. So take that into consideration when I'm with this next point. We already know, and I've experienced it firsthand, extreme bias on behalf of federal judges and state judges. Extreme bias. This is no different. As I'll get into in the court case here, this Eileen Cannon was very brazen and open about taking a case where there was no standing and no jurisdiction. So, but you look at who, but you got to look at who the plaintiff is. She's doing it on behalf of the guy who appointed her, Donald, the biggest loser, Trump. So we know that they have extreme bias. But this is really important because an important part of logic is not to generalize that just because this Eileen Cannon is extraordinarily biased, doesn't mean that every single judge at the federal level or the state level is. I think that the brazenness of the corruption has to do with who the plaintiff and defendants are. If it's just a nobody and it's the government and especially the IRS, we know things are going to be tilted severely against us. Right? We've seen it time and time again. I get that. However, we want to use good logic that not every single judge is corrupt or biased so heavily in favor of a party that they will throw the book out. And so keep that in mind. Remember, the 11th Circuit Court of Appeals, and this decision, there are three judge panel, no dissent, and I think at least two of the three are Trump appointees. So that's really, really important here. So, like I said, the 11th Circuit, this panel excoriates Trump and his attorneys, and of course, Judge Eileen Cannon, who probably one of the single worst cases of judicial corruption in recent history that we've seen. This is just wow. Let's get into an examination of what the court actually said. It's not that long. I'm not going to go through everything. But the appeal requires us to consider whether the district court had jurisdiction to block the United States from using lawfully seized records in a criminal investigation. The answer is no. So right off the top, right off the bat, former President Donald J. Trump brought a civil action seeking an injunction against the government after it executed a search warrant at his Mar-a-Lago residence. He argues that a court-mandated special master review process is necessary because the government's privileged review team protocols were inadequate because various seized documents were protected by executive or attorney-client privilege, because he could have declassified documents or designated them as personal rather than presidential records, and if all that fails, because the government's appeal was procedurally deficient. The government disagrees with each contention. These disputes, this is where it gets good. You'll notice if you've read Government Indicted or Adventures in Legalland, which you could get in the description if you don't have a copy already, or if you just want to help support the channel. These disputes ignore one fundamental question: whether the district court had the power to hear the case. After all, federal courts are courts of limited jurisdiction. They possess only that power authorized by Constitution and statute, which is not to be expanded by judicial decree. I've been in IRS situations. They just ignore this. That the presumption is that the court does not have jurisdiction, and until the plaintiff, the one who relies on jurisdiction, actually proves it with evidence, the presumption stands. Now, we already know the bias with these federal judges when the IRS is coming after you. I get it. This case was such an expansion, huh? So they possess only that power authorized by the Constitution and statute, which is not to be expanded by judicial decree. This case was one of such an expansion. Exercises of equitable jurisdiction, which the district court invoked here, should be exceptional. Our precedents have limited this jurisdiction to a 4-factor test. Plaintiff's jurisdictional arguments fail all 4 factors. So I'm going to go through, I want to get to the actual decision. These facts are pretty well known. So, because federal courts lack general jurisdiction, it is to be presumed that a cause lies outside of our limited jurisdiction. This is something I just discussed. The burden of establishing the contrary, this part is very important, like I just mentioned. The burden of establishing the contrary rests upon the party asserting jurisdiction. Again, plenty of experience in the federal court where that is completely ignored. They don't do it. Here, they did. And it's bigly because we're considering who the plaintiff is. It's a former president. But they're not going to bend over backwards for him. They're actually going to apply the law. They're actually going to be fair. So this is one of those generalization busting decisions. We can't just go and say that they're all corrupt. It's just the same as people who claim that about fake news. Fake news! That literally every single thing that the mainstream media does, whether it's print or TV or radio, all of it is just some moron scripting it. Fiction. Not true. Doesn't mean that there's not bias in the media, and it doesn't mean that they don't have stories that are actually fake. Look at Fox News. It just means we have to be discerning. We have to look. You can't just accept or reject everything. You have to use critical analysis. You have to use you have to use some logic, some reason. So that's what this particular case does. It's the same thing as like when you have someone like Larry Krasner get elected in Philly. It is a generalization breaker. It broke it for me that I thought there was no point in voting whatsoever. And I was wrong. And I changed my belief based on the facts. This does the same thing. This is a generalization breaker. So if you think that every single judge is corrupt, if you think that that it's all scripted, no. This goes contrary to that. This is evidence. This is proof. Not so. I hate to say it, but you got to go with the facts. We have to go by what the facts tell us. Only the narrowest of circumstances permit a district court to invoke equitable jurisdiction. Such decisions must be exercised with caution and restraint, as equitable jurisdiction is appropriate only in exceptional cases where equity demands intervention. And very clearly, this is not one of them. And this is a big one. It is a familiar rule, and this was talked about a lot in the media. It is a familiar rule that courts of equity do not ordinarily restrain criminal prosecution. Pretty long-standing rule. When we examine plaintiff's arguments about the Richie factors, we notice a recurring theme. He makes arguments that, if consistently applied, would allow any subject of a search warrant to invoke the federal court's equitable jurisdiction. That understanding of Richie would make equitable jurisdiction not extraordinary, but instead quite ordinary. Yeah, it's just simple, straightforward reasoning. Our precedents consistently reject this approach, which is why so many people publicly came out against what this Judge Eileen Cannon did, that it was so wrong. There was just absolutely no legal and factual justification for what she did. She was obviously just doing a favor to the scumbag who appointed her, this guy. So then they go through and they show that all 4 points of the Richie standard, all of them, They didn't meet a single one of them. I love this. This is something that you only usually see this when a poor person is defending themselves. Not a so-called billionaire with $1 million law team. Okay? This is what these paying millions of dollars. Well, maybe they paid up front, but lawyers who are some of the but you're talking some really high-profile lawyers who their firms are multi-million-dollar firms. These are the top. Okay? Now, whether they get paid or not, it's a different story. You're talking about top-end lawyers here. All these arguments are a sideshow. Nice. That is great. See, that's why I say losing bigly. Losing like plaintiffs like the likes of which we've never seen before. And here, and the excoriation continues. The law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant. Nor can we write a rule that only allows former presidents to do so. Either approach would be a radical reordering of our case law, limiting the federal court's involvement in criminal investigations, and both would violate bedrock separation of powers limitations. Accordingly, we agree with the government that the district court... Now, come on, they're being nice here, but they're still slamming them hardcore. Accordingly, we agree with the government that the district court improperly exercised equitable jurisdiction and that dismissal of the entire proceeding is required. The district court, this is great. The district court improperly exercised equitable jurisdiction in this case. For that reason, we vacate the September 5 order on appeal and remand with instructions for the district court to dismiss the underlying civil action. Yes. That is a slam. And again, this isn't fake news. This is right from the court, 11th Circuit. This is not fake news. I'm sure that that Trump has put something out about how outraged he is about the court and how they're the evil baby-eating Democrats. They got to these judges I appointed. But it shows not every single federal judge is corrupt beyond help. It shows that they can be fair, even when they have a very rich, very high-profile litigant. And here, they smack them down. So it's something we get. Look, we have to have our opinions conform to the facts. This is not a case of where the court is not ruling according to the law. They break it down right throughout this right throughout the 21 pages, based on the facts and the law before them. And they ruled that this federal judge, this Eileen Cannon, heard a complaint, and took jurisdiction where there was none. Clearly there was none. And they did the right thing, and they ruled fairly based on the facts and current law. So we have to accept, we have to break any generalization we might have. I know I have to. I had already broken that because I've seen it so many other times. This is just one of the best examples of it. This is just a fantastic example of the facts going counter to our generalization that courts are corrupt beyond redemption. Now, this doesn't mean that if a little person like me, if I was to if I was to bring the same appeal against Eileen Cannon, chances are I'm going to lose. I just don't have, but we can't make a blanket statement, a generalization that all federal judges are irredeemably biased and corrupt, because this is some hardcore evidence that is not true. How many are there? I don't know. But this sets them apart. It's just like you can't say that every single prosecutor, you can't accurately say that every single prosecutor is pro-government and irredeemably biased in favor of the government and corrupt, because Larry Krasner proves that generalization wrong. And it's generally just bad logic to use a generalization, like a faulty generalization. where it's wherein a conclusion is drawn about all or many instances of phenomenon on the basis of one or a few instances of that phenomenon. It is an example of jumping to conclusions. For example, one may generalize about all people or members of a group based on what one knows about just one or a few people. So it's just bad logic. So just as we can't use Eileen Cannon as an example for all judges, then again, we can't use these three judges as an example for all judges, because not all judges are going to rule fairly based on the law and the facts. So let's stick to some good, sound logic and not make not really make generalizations. That's all I got for this. I'm really glad that this came out. If this does not break your generalization that the courts are irredeemably corrupt and biased, let me know your reasoning in the comments. And if you'd like to help support the channel, I have all the links in the description. You can get one of these awesome shirts, okay? You can get one of these awesome anarchy shirts. You can also get an ebook of Adventures of Legalland and Government Indicted. Again, that is in the description. I'm Mark Stevens. This is the No State Project channel, and thanks for watching.